The Endangered Species Act of 1973 is a critical U.S. law that protects species at risk of extinction by conserving their habitats and preventing harm to listed plants and animals. It requires federal agencies to ensure their actions don't jeopardize endangered species and makes it illegal to harm them. The ESA has successfully saved many species like the bald eagle and gray wolf, though it has faced criticism for restricting land use. Despite some controversy, the ESA plays a vital role in preserving biodiversity and protecting ecosystems. The ESA was introduced and signed into law by President Nixon in 1973. Stemming from the Lacey Act of 1900, it has seen many adaptations and versions before it finally became the bill that we know it as currently. It is considered to be one of the world's strongest environmental protection laws, and some key provisions include species listing. Endangered status identifies the species is at an immediate risk for extinction, and threatened, where a species is likely to become endangered in the near future. Habitat protection, where the ESA designates critical habitat areas essential for the survival and recovery of listed species. Prohibiting actions that would take listed species. Recovery plans that outline the actions necessary to help species recover to the point where they no longer need ESA intervention. Interagency cooperation, where federal agencies must work together to ensure that activities that are funded or authorized don't jeopardize listed species or critical habitats. The Endangered Species Act has received several amendments over the course of its 51 years since implementation. The first major amendment was in 1978 when the Tellico Dam was halted by U.S. Supreme Court after discovering the habitat of an endangered fish species, the snail darter, would be impacted by the almost completed project. Although the dam had previously received federal funding, Congress amended the ESA to allow potential exemption from ESA regulation for similar projects. The next amendment was the Endangered Species Act Amendments of 1982, where Congress prohibited the removal of endangered plants from federal land, and it also played a major role in the future of how to determine or decide how a species is listed. This amendment also introduced experimental populations, which do not receive full ESA protection because they are groups of plant or animal species which are limited to specific geographical locations. 1982 is also when we began to see incidental take permits that allow otherwise unlawful activity if they submit a habitat conservation plan. In 1988, the U.S. Fish and Wildlife Services were required to start publishing detailed reasons for the necessity of an emergency listing, and they must notify the states affected as well as having the listings take effect immediately. In addition to this, they were required to monitor and report on the status of all previously listed species for a minimum of 5 years. In 2004, a minor amendment was included in the National Defense Authorization Act of 2004, which allowed the Department of Defense to be exempt from designating critical habitats for listed species on its land so long as the U.S. Department of the Interior approved a natural resource management plan. The Threatened and Endangered Species Recovery Act of 2005 was introduced in the U.S. House by then Republican Representative Richard W. Pombo, but the bill was never introduced for a full vote in the House of Representatives. Robert B. Kiter's article explores the concept of ecosystem management, which means managing entire natural systems rather than focusing on one species or resource. He explained how federal laws, like the Endangered Species Act, are now interpreted to support this approach, even though they were originally designed to protect individual species or resources. This approach requires both public agencies and private landowners to work together because ecosystems don't follow human boundaries. But Kiter points out that there are obstacles, especially because private landowners often resist new regulations, and property rights laws complicate this process. Property rights are constitutionally protected under the Fifth Amendment, so the government is prohibited from taking property without just compensation. And the U.S. Supreme Court ruled that this takings limitation extends to regulatory restrictions on property use, which is where half of the Dolan standards is derived from. This is significant because it highlights how laws like the ESA are evolving to protect whole ecosystems, since existing law does not speak in terms of ecosystems, ecosystem management, or biodiversity. Although the ESA was originally focused on individual species, ecosystem management is a broader approach that fits with the ESA's goal of preventing extinction. But by focusing on habitats and regions rather than just single species, ecosystem management helps sustain biodiversity, meaning all parts of nature are healthier. However, Kiter points out that our laws are not fully set up to support this approach, especially in private lands, and to make ecosystem management a reality, we might need to update laws to reflect the interconnected nature of ecosystems. This study by Caitlin Troyer and Leah Gerber looked at the updates made to the ESA recovery plans. Currently, the ESA requires recovery plans to help endangered and threatened species survive and recover, and the authors found that recent updates have made these plans better at addressing the main threats that species face, like habitat loss or pollution. They also found, though, that major threats are often prioritized over minor ones, which might leave some risks unaddressed, and the same is being seen for direct versus indirect threats. The study highlighted a gap in monitoring, meaning we're not always tracking whether our actions are actually helping species recover, and they also pointed out that animals and plants aren't always treated equally in these plans, with animals often getting more detailed attention. This difference could affect the ESA's goal of protecting all endangered species fairly. This article is significant because it directly ties into the mission of the Endangered Species Act, which was created to protect species from extinction. The findings support the idea that we need strong, specific actions for each species' unique threats, and by improving threat management, the ESA's recovery plans can better help species survive in the long term. The study also highlights the glaring bias that exists and that monitoring is an area that still needs work. Monitoring is crucial because it allows us to know if what we're doing is effective, which is central to achieving the ESA's goals. Finally, ensuring that plants receive as much attention as animals in recovery plans is important for fairness and for meeting the ESA's requirement to protect all species equally. The Dolan versus City of Tigard case and the ESA both involve situations where the government places conditions on private land to serve public goals. Dolan emphasized that government restrictions must be proportionate to their purpose, a standard that can apply to cases under the ESA when private landowners argue that habitat protection requirements are too restrictive. Courts may consider Dolan's rough proportionality standard in ESA cases, ensuring that conservation conditions are necessary and fairly applied. This case also reinforces that while protecting endangered species is crucial, it must respect property owners' rights under the Constitution's Takings Clause. The Sheetz versus County of El Dorado is an example of the shepardizing process by continuing to uphold the Takings Clause of the Fifth Amendment, but this ruling ultimately reinforces a core principle of U.S. constitutional law. Property rights cannot be unfairly encroached upon by the government without sufficient justification and fair compensation. The Supreme Court examined whether broad, legislatively imposed fees like traffic impact fees must meet the same standards as individually assessed fees, and the court ruled that legislative and administrative conditions on permits both need to meet the Nolan-Dolan essential nexus and rough proportionality standards. This ruling is significant for property rights as it protects landowners from broad fees that don't directly relate to their specific development. And now, all levels of government must justify that imposed fees are fair and directly tied to the impact of each project, impacting future land use planning and local government fee structures.